Welcome everyone to our webinar on work health and safety. What are your business's legal obligations? My name's James. I'm a practice group leader in LegalVision's employment team, and I'm joined here today by my colleague Dickson. He's a lawyer in the team. Before we do start, we'd like to start with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Before we begin, a couple of quick housekeeping items. So you're going to be emailed a copy of this recording. That'll come at the end. If you've got any questions, there's a box there, you can, the chat box, you can submit them. We will try and get to as many of them at the end. And then finally, there will be a survey as well, and we would be really grateful if you could fill that out. Surveys are really important for us, just so we can keep making sure that these webinars are as useful and helpful for you as possible. So we really do welcome all of your feedback, please. All right, what are we going to be discussing today? So firstly, what is work health and safety? What are the duties and who do they cover? Penalties for getting it wrong. And then some practical tips on how you can make sure that you're complying. We're mostly speaking about work health safety obligations today, but we'll also talk just very generally about some of the other areas of exposure that your business might have in relation to health and safety issues. And then, as I mentioned at the end, we'll be answering some of your questions at the Q&A session. All right, well, we will just jump straight into it because we've got a bit to cover. I want to talk about what work health and safety is. So this is also known as occupational health and safety. And it applies to basically all businesses in Australia involving the management of risk to health and safety of workers in workplaces. Historically, you had every state and territory had their own OH&S laws, so occupational health and safety laws, and around 2011, there was a move to harmonise those laws. So basically bring every state and territory under the same laws, same obligations, to make it easier for businesses to know exactly what obligations they needed to comply with. Since 2011, every state and territory has adopted these standardised laws, except for Victoria, who are yet to come on board. The obligations in Victoria are relatively similar, cover similar things. But for today's purpose, we're going to be talking about the WHS obligations and what's in the WHS laws, starting with the duties and basically who they apply to. Now, the upshot here is that WHS duties apply to everyone at all levels of a business. So the starting point is that they cover a PCBU. Now that's a person conducting a business or an undertaking. This is a term that covers basically any kind of business. It's going to capture sole traders, companies, partnerships, any structure that you've implemented to run things. This will capture. So instead of using the term, an obligation on companies or on employers, we have a PCBU as the definition. It's extremely broad. There's no getting around it. Within that organization, you've also got obligations under the law on officers, and that's effectively senior management, your C-suite executives in your business. They have their own express obligations under the legislation. And finally, workers themselves. So every worker has obligations under the WHS laws in their personal capacity. So we'll walk through those duties at each of those levels, starting with the PCBU's duties. So a person conducting a business or undertaking must ensure, so far as is reasonably practicable, the health and safety of workers and others in the workplace. We'll talk about what reasonably practicable means shortly, because that is the key element of this. But effectively, this obligation on the PCBU extends to doing things like providing and maintaining safe work environment, safe plant, safe structures, safe systems of work, making accessible and adequate facilities, your washrooms, your lockers, your dining areas, making sure that there's provision of instructions, training, information, supervision, and then of course monitoring the health and safety of workers and the conditions at the workplace. So just a reminder there that when we're talking about a PCBU, we're effectively talking about the business or the company, the employer, a very broad definition, but this is your primary duty. And the critical part here is reasonably practicable. So we'll talk about, okay, what does reasonably practicable mean? How far do you have to ensure this health and safety obligation? So moving on to the next slide, reasonably practicable. So the upshot is this is not an absolute obligation. You're not required to eliminate every single risk in your business. After all, people can they can trip over flat carpet, they can fall downstairs that have perfect grip and railings, that they could they get back issues from sitting at ergonomic chairs that you've been encouraging them to stand and stretch at appropriate intervals. The upshot is it's impossible to get to zero risk in a business, so you're required to eliminate or minimize risk to the extent to what is reasonably practicable. If we're going to actually figure out what that term means in practice, we take a look at things like the likelihood of the hazard or risk occurring. So if there are obvious risks, you're more likely to be required to address them. Things that are unlikely to happen, well, you're less likely to have to take steps to prevent them. But all of these things get mixed in together. So the degree of harm is relevant. A risk that's going to pose a very serious injury, well, that might require more of your attention than a minor one, but it's still going to be determined by reference to the likelihood of that risk occurring as well. You'll also take into account things like, well, what knowledge about the hazard or risk and ways of managing it is available. So not every risk is actually yet known to us, and that's relevant. We can't eliminate or minimize risks that we are unaware exist. Now, Safe Work, they're the regulator in this space, the government regulator. They will publish a lot of material about known risks and also steps that you can follow to minimize them. And so the fact that that material is out there becomes very relevant to determining whether or not you could have known, for example, about particular risks. Following on from that, well, there's also, okay, what options do you have to eliminate or minimize it? Yes, not everything can actually be minimized or eliminated, and others definitely can. So that is also a factor when we're considering how far do you have to go in relation to this obligation. And then mix all of that in with the cost. Cost in this sense is relative. So the size and the financial position of your business is going to have an impact on how far you have to go when you're minimizing those risks. Something we should probably note, I guess at this stage, is that mostly when we're looking at this, our minds turn to physical risk. Things like if there's a leaking fridge and water in the staff kitchen, okay, we've got a risk. We can eliminate it by mopping and fixing the fridge. We can minimize it by drawing people's attention to it. And so that can be a more simple approach to determine, okay, well, how far do we have to actually go here? But it is important to remember that these health and safety obligations extend to all risks to health and safety. And in many businesses, those risks are actually non-physical. So they relate to things like stress and anxiety conditions, harassment issues from inappropriate behavior, maybe poor management, thinking about the steps you can take in relation to eliminating and minimizing non-physical risk then becomes critical, and often sometimes a little bit trickier than responding to your obvious risks like slippery floors or edges with no railings and those types of things. So that's at a very high level, the primary obligation on the PCBU. We'll also then now look at what the officer's obligations are. So officers effectively have to exercise due diligence to ensure that the PCBU complies with their duties. Your officers, look, they're the people who can make decisions that will impact the whole or a large part of the business. So directors, secretaries, it's covering usually your senior management, but the process certainly there is actually identifying who your officers are is something that you're going to need to do, and they need to be aware of those obligations as well. So there's often a piece of work to be done in that sense, actually just identifying who the officers are. Now this due diligence obligation, well, what does that actually mean? It basically requires them to take reasonable steps to acquire, keep their knowledge up to date, and that's their knowledge in relation to WHS matters. They need to understand the hazards and risks associated with the business. They need to make sure that the PCBU has the right resources and processes to manage those risks. They need to make sure that a process there to receive information about respond to risk. So, WHS incident reporting issues like that, hazard registers. They need to be making sure that all of that's happening. And they're also the ones that are going to have to ensure that the PCBU actually has processes and procedures in place to make sure that there's compliance with all of these WHS duties. So yes, look, in each business, you'd expect that the officers firstly get identified, and then there's a formal process in place to ensure that they're carrying out those due diligence obligations. And we'll touch on that a little later when we're talking about some compliance tips. Finally, the third level of obligation or duty holder are the workers. So workers have a duty to basically take reasonable care of their own health and safety, and also the health and safety of other employees or other workers in the business. They have to follow work health and safety instructions, and they've got to cooperate with the PCBU in relation to the policies and procedures that are there. So those are legislative obligations that sit on those workers. They need to be made aware of those obligations, notwithstanding that they hold the obligation themselves at law. Employers or PCBUs need to be making the workers aware of the obligations, and that's something that you can often do, say, through a work health safety policy. That'll outline everyone in the business their particular obligations. And I think, helpfully for PCBUs, for employers here, the fact that workers do have their own obligations under law, well, that can be quite a useful tool for employers to, I suppose, make use of when they're actually trying to get employees or workers to comply with safety procedures. All right, so that is yes, at a high level, your duty holders. I think I'll hand over here to Dickson, basically to run us through the penalties. So what are we up for if someone fails to comply with those duties?
Yeah, great. Thanks, James. So if a PCBU officer or worker doesn't comply with their duties under WHS law, they could actually be committing an offence and face penalties depending on the severity of the breach. In WH laws, there are 3 categories of offences, and these are outlined in the next slide. Quite a bit of information there, but we'll work through it together. As you can see, the relevant category of the offence will depend on factors such as whether an individual was exposed to a risk of death or serious injury or illness, and whether the duty holder was reckless in relation to the risk. You'll see on the right-hand side of the table, the penalties for breaching WHS duties include pretty significant monetary penalties, as well as imprisonment. So for example, the most serious offence, a Category 1 offence, which currently carries penalties of up to $3 million for a company, basically applies where someone is reckless as to their duty, and that failure exposes someone to a risk of death or serious injury or illness. On the lower end, a Category 3 offence, which still carries a potential $500,000 penalty for a company, is where there is non-compliance with a work health and safety duty. The upshot here is that these are very serious penalties, and they kick in even for what some might call minor non-compliance. Now, beyond these penalties, WHS laws include other enforcement options, such as notices. And examples of notices that WHS inspectors can issue include an improvement notice to remedy or prevent a breach of WHS laws, a prohibition notice, which prohibits you from carrying on an activity that involves a serious risk to a person's health and safety, and a non-disturbance notice to require you to prevent the disturbance of a particular site for a specified period. And you could face severe monetary penalties if you fail to comply with any of these notices. Now, on the very serious end of the potential offences here is industrial manslaughter. This is something which has more recently become an offence, and it demonstrates a continuing push from legislators and regulators to make compliance with safety laws a really critical aspect of business. It's come about in circumstances where a lot of commentators consider that monetary penalties, even where they are significant, are just not enough of a deterrent to make businesses comply with their obligations. So the creation of a criminal offence carrying jail time is the approach to force greater compliance. So industrial manslaughter, what is it? It's a crime where you act or fail to act in a way that leads to the death of a worker. It's slightly different in each state and territory, but broadly requires there to be recklessness, intentional conduct, or negligence on the part of the person committing the offence. The purpose of these laws is to prevent workplace deaths and deter you from breaching WHS duties owed to workers. And all Australian states and territories, except for South Australia and Tasmania, have industrial manslaughter laws. South Australia's government has proposed to introduce industrial manslaughter laws, but there are currently no plans to introduce them in Tasmania. As you can see in this next slide, the penalties for industrial manslaughter offences include significant monetary penalties and imprisonment. And in light of these harsh penalties for WHS offences and industrial manslaughter, you should really be taking a proactive approach to safety matters to help reduce the risk of workplace injuries and deaths. So I'll now hand over to James to address how can a business ensure WHS compliance.
Thanks, Dickson. So, look, firstly, I just want to note that, what we've outlined here in terms of what you can do to ensure compliance is going to be at a high level. And there are different approaches that I guess every business can take when setting out its own compliance process. So it can look very different in each business and particularly different industries which are responding to different risks. But in general, what you'll need to be ensuring is that first up, you identify the duty holders in your workplace. Ensure that they understand their obligations. So that's your first step. You obviously aren't going to be able to comply with your obligations where you're unaware of them. And look, in terms of letting everyone know their obligations, well, you can do things like workplace safety inductions. You can have a work health safety policy to inform all those duty holders of their responsibilities, as well as the potential consequences for them if they're going to contravene them. Remember too, a person could have multiple duties and more than one person can have the same duty at the same time. So for example, your officers are going to have obligations as an officer, but they can also have those obligations as a worker. Number two, undertake a risk management process and then take action. So in a broad sense, start by identifying the hazards. Sometimes this is something you can actually do yourself, or you might need to take specific advice from a WHS expert and that's not necessarily going to be us. Different industries are going to have different experts who are typically dealing with the actual physical risk that you might see in a particular workplace. Make an assessment of those risks. So assessing the risks, that's going to help you understand how much you need to do to either eliminate them or to reduce them. So, as we've talked about, not every single risk has to be eliminated. That we know that's impossible, but you'll be able to make a decision on what most needs your attention and the resources that you do have available. You're then going to control your risks. Now, this is really broad, but it boils down to actually implementing your processes and procedures that are going to work to control, limit your risk to health and safety. Some industries are going to have endless requirements in relation to compliance with codes of practices, endless procedures to follow when you're carrying out your tasks, your safe work information statements, all those types of things. Other industries are going to have a much lighter touch, and this is really going to depend on what what has been identified as the risks to health and safety, and also the resources available out there, particularly from safety regulators in relation to what's expected of you and compliance with them. Finally, reviewing hazards and control and your control measures, it's an ongoing process. So your WHS compliance is a sort of never-ending process. You need to continually change it and refine it. Now, you might be refining things or improving your processes because new information about risks comes to light. Safe Work might publish a guide to a particular aspect which is relevant to your business, or you might be refining your processes because there was an incident in your workplace and that actually highlights a risk that you weren't aware of when you've actually had something occur, whether that's an actual, an incident or a near miss. You can always take the opportunity to learn and improve your processes from that. But look, the important point here is that yes, your compliance, your safety compliance, it's not a set and forget process. It's not buy a one policy and put it in the top drawer and then consider yourself compliant. Finally, there's record keeping. Now, the records, you're going to keep records of your risk management process. That's your information about what you've identified, what you've implemented, the consultation that you've been carrying out, records of the training, and plans to change. This will be part of the officer's due diligence, as well as just the PCBU's obligations. The benefit of doing this is that all these records are effectively going to be evidence of your compliance with all of your obligations. So if regulators or inspectors come to your business, they could do that randomly. They have the right just to turn up and enter your business and ask for documents. Or they might do it in response to a claim or an incident. Well, you're going to be very well assisted by being able to show, a very nice paper trail of all your ongoing efforts to ensure health and safety and how you've actually met your obligation. So, I guess that's the majority of what we wanted to cover in relation to work health safety and your obligations under work health safety legislation. I mentioned earlier, there are some other areas that your business might be exposed when it comes to health and safety matters. And I'll hand back to Dickson just to run us briefly through those.
Yeah, thanks, James. So in addition to your obligations under WHS law, you have a common law obligation to ensure a safe place of work. So if your employee suffers an injury at work, you may not necessarily be prosecuted by a WHS regulator for breaching WHS law, but your employee may bring a claim against you directly. And most of these are handled by your workers' compensation insurance. Workers' compensation is a form of insurance payment to employees if they are injured at work or become sick due to their work. In short, the approach of the workers' compensation system is to limit the employee's ability to sue you for breaching their contract or your obligations to them, and provides a no-fault system whereby if they are injured at work, their wages and medical bills are covered by the insurer. It's important to know that employees in each state or territory are required to take out workers' compensation insurance to cover themselves and their employees. And as James alluded to earlier, another area of exposure relating to workers' health and safety are psychological risks. While it's common to consider physical risks to your employees' health and safety, you also need to consider psychological risks, which may result in work-related psychological injuries, such as depression and anxiety. Workplace bullying is an example of a psychological risk that can amount to a breach of your WHS obligations. If bullying occurs in the workplace, you may be vicariously liable for the bully's conduct, and the affected employee may bring a workers' compensation claim for psychological injury. They can also make an application to the Fair Work Commission to stop workplace bullying. The Fair Work Commission cannot issue financial compensation for workplace bullying, but they can make orders for the business to deal with the bullying. Now, to address this area of exposure, you can implement an anti-discrimination, harassment and bullying policy, which prohibits workplace bullying and is a useful tool in demonstrating that you took reasonable steps to prevent the bullying and other forms of non-physical injuries from occurring. Now, that concludes the main content of our webinar, and I know we've covered a lot of ground today. So if you are interested in consolidating or learning more about your WHS obligations, you can download our Safety Essentials for SMEs guide. You can do that through the handout section there in your panel. Also wanted to draw your attention to an upcoming event next Thursday on the topic of capital raising that may be of interest to you, and you can register at the link that you can see there on the slide. And we are going to answer your questions very soon, but just to give you a bit more time to submit them, we're going to tell you about our membership and special offer. LegalVision membership is an alternative to typical hourly rates you experience with other law firms. And for a fixed monthly fee, you not only receive cost certainty, but all-inclusive benefits such as unlimited document review, which would include reviewing your safety and employment policies and contracts. Includes unlimited consultations, which means you can book as many meetings with us as you need to discuss your WHS or employment needs, or for any of your other business legal needs as well. You can talk to any of our lawyers, including our corporate, contracts, franchising, leasing and trademark lawyers, depending on your business needs. The membership also offers unlimited trademark registrations and much more, all for a very reasonable monthly fee. We're also offering a free consultation for webinar attendees to learn how we can help you with your work health and safety compliance or other employment issues. To book a complimentary consultation, just leave your contact details in the survey that will appear after the webinar ends. Alternatively, you can email reply@legalvision.com.au and mention that you watched this webinar. So now we'll answer some of your questions, and thanks to everyone who've submitted questions so far. Don't hesitate to keep submitting some more as well. So first question that we have here, and I might combine a couple of questions that are related. So what are the key questions that employers should ask about a staff's work from home work conditions? And got another one here, which is related. All of our staff are working remotely. How do the WHS regulations impact us as we have no control over our team's work environments?
Okay, so they're really good questions, and this is something that's come up obviously for a lot of businesses over the last 18 months, 2 years, with work from home becoming very common for all of us. The starting point is that your WHS obligations do extend to an employee's home when they're working there, so that effectively becomes the workplace. If we come back to that primary obligation, which is that you need to ensure, so far as is reasonably practicable, everyone's health and safety. That's exactly where the fact that an employee might be at home and you get limited control over their environment, well, that gets taken into account in terms of, okay, well, how much can you actually reasonably do when they're in a completely different space to you? But it doesn't mean that you don't have to do anything. And a very common approach here is to have employees fill out working from home checklists. Certainly something that we prepare, and it's effectively a series of questions that an employee can answer in relation to their space that they're working from at home. So that might be anything like, are there power cords from your computer in the way that you could trip on? Is the temperature regulated? There are very specific things about the height of the computer. What type of chair are you using? Is there adequate light and air filtration and all of those types of things? Now, if an employee goes through the process of sort of warranting to you that yes, all of those things have been thought about, you're going a very long way to ensuring that you're complying with your obligations, because there really is only so much you can do. And look, there definitely are cases out there where employees have been working from home, they've been getting construction work done at home, and then they've in one instance, they've tripped over a cord and fallen down the stairs, and they've successfully found the employer responsible because they didn't take any steps to do things like say, well, how safe is your home environment to work from? Now, of course, if an employee fills that out and says, yes, I've got an adequate chair and my computer's at the right height and whatever else it might be, but then they decide to sit on the couch all day, with a neck bent the wrong way with a laptop, on their lap, and then they develop some kind of back injury from it. Well, from a work health safety perspective, the fact that you've actually required them to follow all of these processes that would have kept them safe, and they then elected not to, is going to mean most likely that you're off the hook in relation to your safety obligations at law. So upshot there, yes, definitely your obligations extend to your employees at home. Yes, you've got to do something, but what you do is going to be limited. And a working from home checklist is a really good way to cover off all of those issues to ensure that their home environment is as safe as it can be, and that they are behaving in a safe way at home.
Yeah, thanks, James. So again, it's about doing what's reasonably practicable in the circumstances.
Yep, that's
another
right.
couple of related questions. So we've got one here about how often should you update or refresh WHS duties within your company? And then more specifically, how often should I be updating a COVID vaccination policy in my business?
Yeah, so as we mentioned, these are ongoing obligations. So updating is something you're definitely going to need to do. Your policies generally, if it's a policy, and look, this is always going to depend on sort of exactly what the policy is. If it's a policy which you've developed to just basically make all your duty holders aware of their obligations, so one which says, well, this is what the PCBU has, these is what the officers need to do, and these are what workers need to do, and make sure everyone's got that. Well, that doesn't necessarily need to be updated until the law changes in relation to those duties. You could certainly take the approach of ensuring that everyone is consistently made aware of those policies so that they don't just forget about them. So for example, when you get a new employee come on board, they need to be made aware as a starting point. Hey, you probably provide them all of the workplace policies, but also your WHS one. And then for everyone else, look, it could be a 6-month thing, it could be an annual thing, where you just reshare your policies with everyone and say, look, just a reminder, these are the policies that we're operating under. You are required to read them, be aware of them, and of course you have to comply with them. And you can take different approaches here. Some employers like to then make sure every employee responds with a confirmation, yes, I have received this, yes, I will comply with it, that can just be a bit of an administrative nightmare sometimes. But if employers are happy to do that, then it's a very good approach to get the employee's agreement. But if not, it can be something, like just an email to everyone saying, here they are, and by the way, you are required. So you don't have to, required to comply with them. You don't have to make sure they write back and agree to all of that, but obviously if you can be very helpful. And now then a COVID vaccination policy. Well, yeah, look, that's a really interesting one, because it's a consistently changing area of law. Now, those policies, there was a time where, it really depended on, okay, well, are you in an industry that has mandatory vaccine requirements, and then that would obviously determine your policy very clearly. And then for others, a little bit more of a grey area as to whether or not an employer could require that. The overarching issue here is that policy is there to respond to a risk in your business, and a risk to health and safety, and that risk to health and safety was and is COVID. But that risk is now, and a lot of people have different views on this, but that risk is probably less now, and therefore, in terms of what you're required to do in relation to it, that's changing. So you probably have some wriggle room in a sense there, if you have a very clear view that you want to maintain a particular vaccination policy or a particular stance on vaccination, you probably still have enough of a risk to justify it. By the same token, for a company that wanted to start relaxing on those types of things, assuming that there's no government requirement to in your particular industry to comply with vaccine mandates, then you're probably at a stage now where you'd be comfortable to relax that policy as the risk is now relaxing. So the upshot there is it very much depends on the risk, and as a business you can respond to that risk.
Yeah, great. Thanks, James. I'm going to keep trying to combine questions just so we can get through as many as we can in the time that we have. So I've got a question here. Interested to understand a company's obligation and liabilities when a staff member or employee comes on board with pre-existing mental illnesses, such as depression, anxiety, that may not have been disclosed or evident throughout the interview, screening and onboarding process. How does this affect the business and its liabilities if and when that employee does have an episode, or worse still, brings a claim against the company for causing an episode? And then there's a related question: if an employee doesn't want to share their health issues, mental or physical, what's the employer's obligation on this? For example, if the employee has provided a medical certificate for a month. Very common questions we get brought to us. So keen to hear your thoughts, James.
Yeah, and tricky ones too. Yeah. So in terms of someone coming on board and they haven't disclosed something to you, this again will come back to this reasonably practicable obligation here. So if someone has a pre-existing health condition, which means, for example, they might be, prone to extreme stress or depression, anxiety, something like that. That doesn't mean that, as a business, you must be, 100% ensuring that absolutely no, no negative instance occurs with that employee, or that there's any damage to their health. In that instance, yes, you need to basically be trying your best to ensure that that person is healthy and safe in your workplace. If there are obvious things that they've identified to you, that might be, say, triggers for them or something like that, well, yes, then it might be reasonably practicable to take some steps and ensure that those types of things are accommodated for that employee. There would be an overlay here potentially with discrimination laws, which effectively require you to make reasonable adjustments for employees with disabilities or other protected attributes, so that they can do the job. So if they've been able to say to you, look, these particular circumstances are going to pose a much bigger risk to my health because of my pre-existing condition, then yes, you're going to be obliged to do something about it. Equally, if you're fully unaware of something and you're otherwise operating a safe environment, then no, it's going to be very hard for you to respond to a risk which you're unaware of, and the law's not asking you to do that. And if they're going to bring a claim that you've, say, caused an episode, that answer really depends on what the claim is. Most likely, if someone is then, say, injured at work and they then have time off, they'll probably bring a workers' compensation claim. And workers' compensation is not really interested in who is at fault. So, for example, triggering an underlying condition might still mean that your insurance is going to cover, it's going to kick in, and that claim is going to be accepted. By contrast, if they're trying to say that you've failed in your WHS duties and that you have breached the law, and they're looking, to try and get penalties leveled against the company, some of the, like those ones that Dickson's walked us through today, then far less likely to be successful in that situation, because the issue there is that you haven't actually caused the episode, assuming you're not, obviously aware of it, and then sort of, being reckless to it in that sense. The next bit about, and yeah, look, sorry if that's not probably 100% clear enough. These things are very case-by-case basis, and I should probably take this opportunity too to say, for any questions we don't get to, or any questions that I don't give you a helpful enough answer on, please do feel free to make use of that consultation. If you have a specific question, we can chat to you about it in that consultation afterwards. And then obviously for those of you online who are members, you can just book in through Prism, and we can obviously have a chat about any of these specific ones. The other issue there is, employees who don't want to share their health issues, whether that's mental or physical, and what are your obligations. So again, on the one hand, if an employee is just saying, look, I'm not fit for work, they give you a doctor's certificate, and the issue that you're dealing with here is you're coming at this from a are they entitled to sick leave perspective. Usually a doctor's certificate is going to be satisfactory evidence, and you don't need to sort of do any more investigating in that sense. They go on their sick leave, they come back to work. But if, for example, there's something which you become very aware of, even say indirectly, or you suspect that there's a risk to their health and safety, you will probably, if you've got our employment contracts, you'll have a right in the employment contract to direct that employee to see a doctor. And for the doctor then to give you information about whether that person can actually safely do their job. If you don't have our contract, you get a contract which doesn't have that clause in it, it is possible under law to sort of imply that you've got that right. So typically if you're actually aware of some kind of concern that the employee can't actually safely perform their job, then you are actually entitled then to direct them to see doctors, get information about it so that you can ensure their health and safety. Now, just looking at the time there, I don't know if we have, there are actually a bunch more questions. I'm really sorry that we haven't got to any of the others. So yeah, look, I would just say, please do make use of that consultation, even if it's just for us to respond to your question there. We'd be really happy to do that. All right then. So I think that's going to wrap us up for today. Thank you everyone for joining us. We really hope that has been helpful, been useful for you. And yes, look, a reminder to make use of the consultation. And there's also going to be a survey that you're going to receive, and once again, we'd be really grateful if you would you'd fill that out so that we can make these as good as they possibly can be. So thanks again for joining us.